Hmm. Pretty interesting group out there. Hey, you may want to turn your camera off. Good morning or afternoon if you're in Australia or something. Today's program will be continuing very soon. You haven't missed anything yet, that's for sure. I'll be running for political office soon for a puppet government. All right, well, this show's not going to get any better, so I'll introduce the speaker now. The speaker is a very mediocre speaker. He's wearing a jacket just to try to pull one over on you. He is a member of the Florida bar, but that's not the bar I see him at most often. And now, without paying any dues, here he is, Alan Gassman.
Oh, thank you very much. That was a wonderful introduction.
Yeah, you bet.
I'm Alan Gassman, and I'm here today to talk about one of my favorite topics, and that is Florida creditor protection. I have been studying Florida creditor protection for about 40 years now, and there's always some surprises. Not only surprises in the law, but also, unfortunately, surprises in what happens to people when they haven't planned or when they think they have planned. So this is scheduled for 60 minutes. It will seem much longer. Afterwards, I'll show you a couple new things about Estate View software if you care. And before I forget, what's behind me on the video? A picture from the Wright Brother Museum. If you've never read the Wright Brothers biography by Eisenstadt, go get it. It's a great, great biography, how these two guys and their sister, and she was key, with a bicycle repair shop, through perseverance, almost dying a number of times, figured out how to fly an airplane and made a big difference in our development. So, without them, you probably would not have those tray things that come up in front of you on the airplanes and the chargers. You probably would not have those yet because we wouldn't have been flying that much sooner. All right, we will qualify this for New York and Florida credit for lawyers, not for any of the other 48 states. It's not good enough for that. And if you're a CPA, we have not registered it, but we can send you a certificate. Can you ask questions? Yes, please do. I welcome questions. They help keep us awake and let me know if I'm saying the right thing or not. So you just click on the upside down pyramid, type in your question, and I might answer it. Some upcoming events, and I welcome you to give me input for these events. A number of you are taking my Tom Dixon masterclass on estate planning. It's not too late to pay to join it. You'd have to watch the old sessions, and then the next new session is Wednesday at noon. We're going to talk about IRA, beneficiary designations and the stretch rules and stretch trusts. And one of my partners, Denicolo or Brandon Ketron, will be joining us for that. It's 2 hours. The whole program is only $250, so, or actually $249 if that makes a difference. All right. Then I'm going to be talking about trusts for free on April 11th for 30 minutes, etc., etc., etc. With Jonathan Blotmacher and Marty Shinkman for Lineberg on April 21st, we're going to be talking about flexible trust drafting. Jonathan has some really cool new stuff, and he's going to share it, I think, for the first time. I haven't seen it yet. If you're interested in playing with Estate View estate planning software, most of you have heard me say this 19 times, so just email me if you have an interest and we'll get you set up. Next week's master classes for this, our free master classes are Monday, Wednesday, and Friday at noon. The Friday at noon class does qualify for Florida and New York CLE. I have a Florida calendar here for you on page 8. It's worth the price of admission. Hanukkah, December 14, start shopping soon if you're going to buy me a gift. And the release date of Jimmy Buffett's A1A album. If you've never heard the A1A album, it's very good. It's very amusing. It was December 1, 1974, before most people knew who he was. So if you have Florida clients, then make sure they pay their property taxes by November 30. Look for their property tax bill March 31, and their vehicle renewal is on their birthday. So you could send them a birthday letter, say, happy birthday, it's time for your vehicle renewal. And as my wife Marcia found out, if you drive without that, it is a felony. They could put you in jail. Map of Florida there. I'm in Tampa Bay, which has about 3 million people now. The map needs to be updated. And here's your airports. So if you're coming to Florida, you don't have to go to Orlando or Miami or Tampa. You could fly to one of the smaller airports if you just connect in Atlanta. Atlanta, I think, goes to all these airports, and these are all good airports. I prefer small airports to big airports. All right, becoming a Floridian. A number of you are not Floridians, and you have my sympathy for paying the state income taxes. Jonathan Blotmacher and I did a very nice presentation because he did 90% of the talking. I nodded and said, a few times on what it takes to become a Floridian. There's a YouTube video. You could search Gassman Blotmacher YouTube, become a Floridian, or let me know and I'll send you a link. But one thing I want to mention is that there is a bankruptcy court case that says that if your assets are exposed to creditors and you move to Florida and then your assets are not exposed to creditors because of the move, then the move itself may be a fraudulent transfer that would enable the bankruptcy court to unwind these assets. So come to Florida sooner rather than later, or Texas. We've got a nice Texan here on listening today. Before the problem arises. After the problem arises, the Florida homestead protection is still going to be very strong, and I'll talk about that in a little while. Now, this deck is hundreds of pages long, and it's a deck that I've used for a 4-hour presentation, which we'll be redoing pretty soon for the New Jersey bar. So instead of pulling out the asset protection slides, I just left all these in, and I'm gonna move around, bob and weave. My brother's name is Bob and his wife is Eve, so it comes to mind, Bob and weave, Bob and Eve. Hey, Bob and Eve. All right, page 36, and this is the one that lawyers should carry this around in their wallets if they live in Florida until you have it memorized. This was my Dale Carnegie course project. What can you explain in 2 minutes? And the visual guide was optional. But what I can explain to a client in 2 minutes, besides why my bills are so high, is that Florida has the longest list of exempt assets of any jurisdiction in the world. And the list of exemptions are here on the left-hand side. No matter what your politics, you got to start on the left-hand side. And then Florida has laws which cooperate in situations, or there's other things that Floridians can do to avoid creditors. And then everything else is exposed to creditors. So just to go over the list real quick so you know, homestead, up to half an acre within the city limits, and up to 160 acres outside of the city limits. And our Supreme Court ruled in the Haveco case, Haveco, that our fraudulent transfer statute doesn't apply to a transfer to homestead. Now, Congress did something else in the bankruptcy code, so it's still not a cakewalk, but what happened in Haveco was that the man allegedly defrauded a brokerage firm with a margin account situation, I believe. And immediately after a $17 million arbitration decision, I believe it was, he moved to Florida and bought a huge house. And the court said whether he was deceitful or not, as long as the money that went into that homestead was not ill-gotten gains, ILLGOTTEN gains, GAINS, the creditor could not reach the homestead. An earlier case, which was one of my favorites before then, was a family was growing marijuana illegally back when it was really illegal. Now it's only somewhat illegal. And they got caught, and the government could not get their house where they grew the marijuana and could not even get their marijuana farm equipment that was a fixture to the barn. So you can't help a client who has a marijuana growing operation by telling them to make everything a fixture to their house. When I read autobiographies in 3rd and 4th grade. I can't remember which one it was, but there was a biography about people back in the 30s had golden doorknobs. That was a big deal. You would have golden doorknobs and you would have golden faucets made of gold. And now I understand why. It's a fixture to your house. I don't think they'll be able to take it. So that's Homestead. That's also a city near Miami, Florida. All right. Also, IRAs of all kinds are exempt from creditors. What does that mean for you guys who are not lawyers, who are fortunate enough not to be lawyers? If an asset is exempt from a creditor, it means that even if I lose a trial or I owe a promissory note and there's a judgment declared by a court that I owe it and have to pay it, the creditor can't take these exempt assets. I sit with them. I have them. I can use them. So it's better to have exempt assets than what they call non-exempt assets, which the sheriff can come get. Then a permanent life insurance policy, not a term policy, but a whole life, universal, guaranteed, universal, variable. Those are all creditor protected in Florida. 401k, pension of any kind. If the judgment is only against one spouse, we have protection for joint assets that qualify as tenancy by the entireties. I'll talk a little bit more about that. 529 college savings plans, I think, no matter what state they're in, that's 98% sure. Then annuity contracts, where you could go to Fidelity and you could give them assets, money rather, and they'll put that money into mutual funds under a tax wrapper called a variable annuity. They'll charge you 0.25% a year, and then you don't have to pay income tax till you pull it out. And our Supreme Court has ruled in the Goldberg case that is an annuity that is creditor proof. And when I draft a grantor retained annuity trust for a client, I always draft it in a way that it qualifies both under the federal tax law, but also under the Florida law as an annuity contract. And I have established very large grantor retained annuity trusts, which make very large annuity payments to clients to both provide creditor protection for those assets, which can then be taken into other exempt assets, and also to provide estate tax protection. And we've even done that offshore. So if the creditor even got a judgment against the debtor and the court didn't say it and said it wasn't an annuity, well, good luck, it's offshore. Hope you can swim. All right, the wages of a head of household. So there's a number of cases in Florida. You get a $10 million verdict against me. Well, I'm an insurance agent. I'm a W-2 employee of the agency. I make $1 million a year. You can't touch it. I put that money in my tenancy by the entireties account. You can't touch it. So the head of household wages. And sometimes people have to get married or get someone to move in with them or start supporting their parents even though they don't like their parents, so that they can meet the definition of head of household. Then the wage account that you put that money into for up to 6 months is clean. So every 6 months, we have the client sweep that account into another account. You know, whether they like to clean up their house or not, they sweep the account. Whether they're a head in their household or not. Okay, Then up to $4,000 of personal assets. There's also, I think there was a new law. I have to admit, we have to update these slides. I think you get it to keep like $8,000 for a car. You get to keep medical devices. So you could have your $3,500 Medicare cart that I guess you could go to work in if you live near your place of business, if you can get a doctor to prescribe it. They probably can't take your hot tub away if a doctor prescribed it, or of course it's a fixture. All right. I know none of my humor is working here. Okay. Now there's a joke here. When a clown moves into a palace, he doesn't become a king. The palace turns into a circus. Turkish proverb. If you haven't seen the John Ringling Museum in Sarasota, go there. Ringling's circus was an amazing circus, and he had a huge Italian pavilion taken apart in the 1800s and brought to Florida and then reassembled. He also has a museum there, which is just as large as any really good European museum, and it's filled with great European pre and post Renaissance art. He donated all that to the state of Florida when he died to make a museum and a park and a home, and it was really good. Oh, the slides are not on the screen. I am so sorry. Aren't these slides nice? I apologize. Stuart, thanks for letting me know at 11:06 that I had forgotten to put on the screen. What I'll do is I'll have the law students re-film the first 16 minutes, and they'll make me look less ugly and the screen look good, but I do apologize for that, and I'm glad that nobody left. Okay. In the middle, Florida, like many other states, have charging order protection. So if you have a judgment against a Floridian and the Floridian owns a limited liability company, say 90%, your sole remedy is to get a charging order. That allows you to get paid if and when there is a distribution. It is not a cakewalk. Once you have a charging order against the LLC, you can't take anything out, and the court is a court of equity, which means that they can make you be fair. For example, hey, you're living in a property that's in the LLC, pay the rent value to the creditor or get out of there. So also be careful. For example, California and Colorado do not have charging order protection. So if I'm a Floridian and I own part of a Colorado or Florida or California LLC, will charging order protection work? Law not clear. According to the Iowa Supreme Court, it's the law of the state where the LLC is formed, not the law of the jurisdiction where you are. So for charging order protection, we commonly use Florida LLCs, Delaware LLCs, Wyoming LLCs, Nevada LLCs. Those work very well. Probably Florida law is going to apply, but not so much for an LLC in Washington State, Colorado, California, or the other states that don't recognize tenancy by the entireties. The same issue applies, that don't recognize charging order as being the sole and exclusive remedy. The same issue applies with tenancy by the entireties. Marcia and I own 90% of an LLC as tenants by the entireties. The LLC operating agreement qualifies, but the LLC is in Colorado. According to the Iowa Supreme Court, that's not going to qualify. Now, that was a corny decision by the Iowa Supreme Court. You get it? Corny, like corn. They grow that in Iowa. Okay. So you can't be too careful. This is where clients come to us and say, well, we have charging order protection because the LLC is owned partly by the Trust for Our Children. We have tenancy by the entireties protection because we own 90% of it as tenants by the entireties of this LLC in Colorado that owns a Colorado condo. Well, you start to worry a little bit. You just can't be sure. Now, one thing we do is not only do we divide up the ownership to get charging order protection, but we also divide it into voting and non-voting. So very commonly, what our firm will do is we'll set up an irrevocable trust for the children, whether the client likes the children or not. have a trustee who's separate from the client but trustworthy and replaceable, have that trustee own 0.5% voting, 2.5% non-voting, have the client own 97% by 96.5 non-voting, 0.5 voting. Now you get a judgment against the 97% owner. Not only would you have charging order protection, but you have voting rights that you can't get hold of. There's a myth that if a bank or a creditor gets a charging order against my LLC, they have to pay the tax on the LLC income. There was an IRS ruling on that, but it was a much different situation. And Lou Mazzillo wrote a good article on that. If you can't find it, just let me know. Because isn't like Missoula a kind of corn that would be in Iowa? So I'm getting corny again. Key vocabulary: exempt asset, an asset that creditors can't touch. Charging order protection, I just defined it. And then what is a fraudulent transfer? It's better to call it a avoidable transfer, VOIDABLE. Florida statute section 726 and also a little part of section 222 says that if you transfer an asset and a primary purpose of that transfer is to avoid a creditor, or you do it when you're insolvent, then the creditor has a certain period of time to set it aside. Usually in Florida, that's 4 years, or it can be the longer of 4 years, or within 1 year of when the creditor finds out about the transfer. You can avoid the 1 year later rule by filing a bankruptcy. The best thing to do, as they say, as Dennis Kleinfeld always said, it wasn't raining when Noah built the ark. So when I do an estate plan, when I prepare an estate plan, one of the things I want to make sure I tell the client is, if we do the plan this way, creditors can reach this, this, and this if you're in a terrible car accident. If we do the plan that way, then creditors can't reach anything, but when you die, there may not be control of the assets. But I think every client has the right to know what the creditor protection implications of their estate plan is. Yes, we commonly use asset protection trusts in asset protection jurisdictions outside of Florida, but they are not guaranteed to work, and they will not work as well as an annuity or a homestead or an IRA or tenancy by the entireties set up before a problem. So just we want everyone to be aware of these issues. So what is tenancy by the entireties? And I guess I'll have to do a part 2 of this someday. Tenancy by the entireties comes about because Florida, when it became a state, adopted the law of England July 4th, 1776. That was so that Florida could be in parity with the original colonies. The original, was it 13 colonies, I believe? Yep. So there was a big gap between the law of England in 1776 and the law of Florida in the early 1800s. Another reason for that was that Blackstone's law treatise was widely circulated in the United States, and it went back to about 1776. So that became the law of the state of Florida. Plus, in addition to that, of course, you had whatever legislation the legislature passed. Well, a lot of debtors came to Florida. That was our history. I mean, who would want to live in Florida in the early 1800s? It was hot. Can you imagine the mosquitoes, the alligators in the swamps? So Florida immediately issued a 40-acre homestead law and said, if you'll come to Florida, you'll get 40 acres for free, and no creditor can touch those 40 acres. So we had debtors from all over the country. come to Florida, get their 40 acres, and then the creditors from up north probably couldn't even find them. But in any event, that's what happened. Going back to England, 1776, women were not permitted to own property. So how was a father to provide a dowry for his daughter without it being taken away by the son-in-law or lost in a card game by the son-in-law? So they invented a fiction. It had nothing to do with Rod Serling or Robert Heinlein. The fiction was this: we're going to imagine an imaginary person, a husband and a wife. It's imaginary because they imagined they were happy. And we're going to be able to give assets to this imaginary person, the husband and wife, and they cannot spend it, mortgage it, or divest it without joint signature. So the husband cannot lose the dowry in the card game. And that became tenancy by the entireties. So without joint signature, the creditor could not reach into it. And it required a number of unities. It wasn't a simple thing to do. They had to go to the scrivener or the lawyer. They had to fiaf it, which was sort of a ceremony if it had to do with real estate. They had to receive it at the same time. They had to own an equal, exact same joint amount. They had to have equal rights to possession. They had to both be on the title. They had to have right of survivorship, and they had to have a marriage. So these were 6 tough standards, and they still exist today in Florida. This is not a cakewalk. When clients walk in and they've got a terrible accident that happened or a guarantee that went upside down, and they give me their 6 operating agreements. This operating agreement says that if one of the doctors retires or gets divorced, the wife the non-doctor spouse has to sell their interest. Oops, that's not tenancy by the entireties. This one says that the doctors who are the members of the medical practice that leases from the LLC can have the right to boot out a spouse. That's not tenancy by the entireties. So we find a lot of issues with operating agreements, and we have savings clause in our operating agreements. I'm glad to send you a sample savings clause if you like. If I send it for Christmas, it could be a Santa savings clause. And it says no matter what, come heck or high water or swamp water in Florida with alligators, this will be a TBE arrangement, and all rights as between any 2 married individuals will be joint with right of survivorship and equal and unitized. And if it's an S corp, you have a lot more savings language and other things that you want to look at. So that is tenancy by the entireties. Now, last I looked, USAA pays great rates of return, but their agreement says it is not a tenancy by the entireties agreement. And some smart aleck banks, used to include Sunbank, have in their account agreement that this will not be a TBE account. Why? Because if they sue one of the spouses because of a bad credit card or something, they want to be able to reach in to those accounts. So this is only a thumbnail sketch. Our book on creditor protection, which I'll be glad to send you a PDF of, has probably 60 pages on tenancy by the entireties. Now, in my opinion, after a lot of study, I believe that 2 spouses can own a revocable trust as tenants by the entireties. What you do is you have them own the beneficial ownership of the trust as tenants by the entireties. But there is this ex-bankruptcy judge in Orlando who wrote 2 or 3 opinions which said you can't have a TBE revocable trust. I just think she was wrong. I say that respectfully. The The cases themselves were right because the trust that she reviewed would not have qualified as tenancy by the entireties, but by having the beneficial ownership owned as tenancy by the entireties, I think that's safe. But if you want to be super safe, what you do is set up an LLC that's owned as tenants by the entireties, and then sign an assignment that says on the death of the surviving spouse, it will automatically be assigned to the TBE revocable trust. And then it should be perfectly safe during the lifetime of the clients. And you got to set up an extra LLC and a little assignment agreement that helps you pay the power bill. So that can be a good thing. But almost every joint trust I see has significant issues. You cannot overly proofread a joint trust because it gets all lost with one of us dies. Is it all the survivor, or is some of it locked up? What was intended? It reads one way here, another way there. So you always want to be careful looking at joint trust. Page 31, and we're halfway through. It may seem like we're only a third of the way through, but we're halfway through. Oh, question. Yes. Anna Maria. By the way, Anna Maria Island in Florida is beautiful. Anna Maria asking the question, I don't know. Can TBE accounts have a pay on death beneficiary? Absolutely. Absolutely. It's important that the pay on death beneficiary would only be paid after the death of the surviving spouse. The surviving spouse will have the right to change it. The Schwab advisor who told you that, I believe, is wrong because I think we've done this with Schwab accounts. And there used to be a Schwab pharmacy that had a lunch counter. Okay, and it's noted in a Tom Waits song, by the way. So now I have an asset protection checklist, and I'm not going to cover it, but you can take a look at this checklist, and if you're not in Florida, you can adapt it to your state. And we mention here not only what's protected from creditors, including, by the way, third-party self-settled irrevocable trusts, asset protection trusts, but what causes liability. And I could do another 1 hour on what causes liability, but I'll tell you what causes liability the most, and that is car accidents, both business and pleasure. And for us in Florida, boat accidents. The first accident is buying a boat. Boat stands for bring out another 1,000. But the second reason not to own a boat is because if you are piloting the boat and it's in an accident, you're liable. Or if you are an owner of the boat and you're on the boat while the pilot is driving the boat, piloting the boat, then you're also liable. So the boat goes in an LLC. So if I'm on my boat, I don't have one anymore, by the way, but if I'm on my boat and so a friend of mine is driving, it's not my boat, it's the LLC's boat. But you got to put the boat in the LLC before you buy the boat or at the time you buy the boat, or you'll end up paying sales tax transferring the boat into an LLC. If you're in international waters, I believe the damages from the accident are limited to the value of the boat. But most of my clients, when they get into their accidents, which an accident is some kid on a wave runner smashes into your boat and you should have known better. And you better not have any alcohol on that boat. So was that fun? Then I've got the CPA's checklist for Florida creditor protection. The CPA is important because the LLC operating agreement I did perfectly. But then the CPA reports the ownership of the LLC is all owned by one spouse or the other. And that's not so good. That's what we call a chink in the armor. So you want to have everything consistent. And then the CPA would hopefully be telling the clients, hey, I see you have a joint account. You should check and make sure it's a tenancy by the entireties account. So, you know, being consistent is good. I will mention that the darn K1 instructions for, is it partners or S corps? The K1 instructions say that when a married couple jointly owns the company with right of survivorship, you give them each a separate K1. Well, guess what? I was taught not always to follow instructions when they don't make good advice. So when that CPA does the right thing by IRS rules and issues that K1, 41 9% to me and 49% to my wife, Marcia. We own it as tenancy by the entireties. The plaintiff lawyer says, aha, chink in the armor. So, like I said, you can't be too careful. All right, on homestead, there's a lot of malpractice traps on homestead. The Florida law of homestead could be an entire 4-credit course. When the Florida Constitution was passed in the 1800s, they did not want widows divested of homestead, and they did not want children divested of homestead. So it's almost like French law of forced inheritance. If I die owning my homestead, Marcia will receive an immediate life estate, and my children will each receive an immediate remainder interest. It's not by probate. It's not by trust. It's not by deed. It is instant on death. And if I have a minor child, there is no way to avoid having all of my children get a remainder interest. If I don't have a minor child, then Marcia gets a life estate. My children each get a remainder interest, but Marcia has a certain period of time to elect to receive a 50% ownership interest, and then my children share the rest of the ownership interest. If Marcia signs a prenuptial agreement or a waiver of homestead, then on my death, I can leave it where I want unless I have a minor child, and then that darn remainder interest to all the children applies. So I've represented the family. Thank heaven I wasn't involved with the planning before the gentleman died. A 16-year-old daughter became the remainder interest owner. No, actually, she became the sole owner. She was the sole child. There was no spouse. 16-year-old daughter became the owner of a $5 million house. The will and trust said, leave everything in trust. Well, guess what? When she turned 18, what do you think she did? You think she followed her uncle's advice and put it in a trust, or you think she kept it? I'm not going to tell you the answer because I don't remember. Okay. So now one savings thing that I've commonly done and it works is the client says, I got a house. It's a 1/4 acre on the water. I love it. Well, I don't want to sell that house and have to buy a bigger house with this big creditor problem. I've got a $2 million house and I've got $2 million in cash. What am I going to do with the $2 million in cash? The answer is buy the house next door, break down the gate, make that 1/2 an acre homestead, and then settle with the creditor and then sell the house next door. So I had a client who bought 6 contiguous condo units. He broke down the walls, and it was one big, silly condo unit homestead, settled his case, and then put in the walls back in and sold the units. So it's kind of neat. Also, if you have more than 1/2 an acre, you might carve out the most valuable 1/2 acre, keep that, take the excess acreage, put it in a family LLC, get charging order, asset protection trust, and other protection, and get an easement where the 1/2 an acre has the right to use the excess property, and possibly make it so the excess property can't even be built on. So that might be a good strategy. I mentioned that you cannot put ill-gotten gains into the homestead. If you do, the courts will allow the creditor to bring it back out. And in one case, the people didn't even know that they got ill-gotten gains. They invested in a Ponzi scheme. They got a good rate of return. They put it in their homestead. Turned out it was Ponzi scheme proceeds, so the court got into it. So also the Buffoni case, which was pretty Buffoni, had to do with Swanee, and in that case, the girlfriend of somebody filing bankruptcy received a fraudulent transfer. She put it into Homestead and they said it was ill-gotten gains. Judge Williams wrote that opinion, and he was a fantastic bankruptcy judge in the Middle District of Florida, who we all remember and send positive thoughts to. Another thing that we commonly do is we talk to clients about confidentiality, limiting liability, and also insurance. So this is a common arrangement for a number of our clients. Instead of owning the home jointly as tenancy by the entireties, we set up a TBE land trust. The land trust owns the homestead. Most courts have said, not only do you have the TBE protection, but most courts have said that a homestead and a revocable trust is safe from creditors. There was one judge named Judge Proctor in Jacksonville who said it wasn't. That was a very interesting case called Bonzano, but he died and nobody has agreed with him. But what I do here is I set up the revocable trust, and then I set up an out-of-state LLC in a state that does not disclose the owner or manager of the entity. So that entity is the trustee of a revocable trust. The purchase takes place, the deed goes to the LLC as trustee of the revocable trust. The county, I've done this in at least 7 Florida counties, the county is willing to not show the owner's name on the website, even though they will allow it to qualify for our homestead tax exemption. And that's a big deal because our homestead tax exemption provides that once it's homestead, the value can't increase by more than the lesser of 3% or the consumer price index. Now, for a rental property, I'd like it to be under an LLC. I can use a Florida LLC if I'm in the business of rental, but I could have the manager of the LLC be somebody who keeps it quiet who the owners are, or an out-of-state LLC. But insurance companies, by the way, insurance companies don't always like this. There are a number of insurance companies that will not write coverage when the client's name is not on the deed, but there are some that will, sometimes at a slightly higher price. Remember Vincent Price? That was scary. So, but now this is silly. Talk about playing games. I put that rental LLC, I put the rental property in an LLC to avoid liability. And the carrier says, nope, we won't cover it under an LLC. Or we'll do a dwelling, we'll do a more expensive policy. Needs to be under a trust. Okay, I'll have the LLC own a trust which will own the house. It's the same darn thing. I just do a land trust in the middle. Insurance carrier says, yeah, we'll give you normal rates. Thank you very much. So now you've got the trustee of the land trust, which could be an out-of-state company. Again, if it's a single individual, you might introduce them to one of your other clients. They're eligible, but if they're in any event, they may want to do a land trust. Here's another thing that we commonly do. And let's say that I'm going to buy a house for my child who's going to college so that he can have better control of the loud parties that he has. Well, I'm not going to put it in the child's name for a number of reasons. Number one, if there's an estrangement, I'm going to lose the house. Number two, it's really an investment, and my wife and I would like to have the benefit of the value of the house. And number three, my lawyer's short on cash and wants to draft a trust. So I draft a spousal limited access trust. The client is the grantor, puts the $400,000 into the trust. The child is the trustee of the trust, not my spouse, because I don't want her sued when one of those loud parties turns into an accident. And my child has the one-time right to withdraw what I put in that trust, which expires in 30 days. My child does not exercise that right. and therefore my child is considered to be the owner of that trust for income tax purposes, thereby qualifying the property for the $250,000 exemption on gain when the condo is sold, giving the child the income tax deduction on the property taxes if that's worth anything. Most children don't itemize. Most children don't keep track of anything, let alone itemizing on their tax return. But who's the beneficiary of the trust? My spouse, my child, my other child, anyone who the trustee decides. I could have my child as co-trustee with Uncle Harry. My child's solely responsible for maintaining the property. Uncle Harry has to approve any distribution. So now everything goes well. The house eventually gets sold. It's taxed at my child's level. My child continues to pay the income tax on the income of that trust at his or her lower brackets, but the trust protectors can eliminate my child as beneficiary and push the assets back out to my wife. The trust is in the trust is an irrevocable trust. So under the Florida Trust Code, which is very similar to the Uniform Trust Code, except in Florida, very few of us wear uniforms. But that trust code says that the beneficiaries are not responsible for the liabilities of that trust. The trustees are not responsible for the liabilities of that trust unless they sign a guarantee or do something wrong. So that is a limited liability trust. And I'll tell you a little secret that we don't often publish, and that is for commercial and residential non-homestead property, there's a 10% cap. If it grows more than 10%, you pay tax based on a 10% increase. That's a big deal here for a few people. But what if they want to put it in a trust to protect themselves from liability? Well, that pops the 10% cap. But the statute says that a change that is not a change in equitable ownership does not trigger that. So what if I set up an irrevocable trust? I'm the sole lifetime beneficiary. My children are the remainder beneficiaries, but I have a power of appointment over the trust, exercisable to my children or for their benefit. I'm also the only lifetime beneficiary of the trust and get whatever I need for health, education, maintenance, and support. Has there been a change of beneficial interest when I transfer that property to a trust where I'm the beneficiary and I have a limited power of appointment? Or is that whatsoever a change in beneficial interest? I don't think it is. So that's how you do the 10% cap. Now, there's other things you can do. How do you give a house to your children? Loan them money at the applicable federal rate is one of my favorite ways. The homestead bypass trust is what I just mentioned. Have the child buy half of it. All those things are important. When the child's married, I like to have the spouse on that house, let them pay the mortgage together. That's a unifying type of thing. Let them sign an agreement with you as the lender that in the event of a divorce, you can foreclose, they have to pay you, or you could buy it. Maybe if you're the lender, you buy it. You have the right to buy it at fair market value in the event of a divorce. Yes, you pay that no good son of a gun, daughter-in-law or son-in-law something to leave, but you get possession of the house as the lender, and then you can give it to your child. You don't need a prenuptial agreement for that. I just thought of that. Let's come up with a name for it. The divorce protected parent loan homestead arrangement. Now, I'll have to have a good acronym for that. Maybe a gimmick. All right. The other thing that I always like to say to clients, if you want things to say to clients, is don't think that your home is a great investment. When you see that the median home in your community is growing by 4% a year, first of all, what's so great about 4% a year? Secondly, your home is not the median home. Let me tell you the main difference between your home and the median home. The median home is always 20 years old every year. My home next year will be 21 years old. And every 60 years, my home will have to be demolished and replaced. So 1 divided by 60 is something like 2.28% of. So if it's growing at 4.5%, subtract 2.28%. for the home part. Now, the property part hopefully is growing at that 4.5%. But here's another difference. My home needs a new roof every once in a while, and it leaks when it rains, and it needs to keep the utilities on when I leave. So should I have a 3,000 square foot house that does what I need, or a 7,000 square foot house because it was a great investment? I also tell young professionals that if you think you need more than 2,500 square feet to be a happy individual with a couple of children, then you should go see a psychologist, not a realtor, or at least see the psychologist first. And if your home is so large that you will not smell the marijuana that your teenage children smoke, then your home is too big, or put them in an area closer to you. If you want to raise children, you should see them every once in a while, because your children and how you raise them is the most important thing in your financial life. Picture yourself with a huge remora fish tied to your abdomen and sucking blood from you. That's your child at age 25 if you haven't raised them properly. Okay, off on a tangent, but I enjoyed it. Probably you didn't. Qualified personal residence trusts work in Florida. After the possessory term, you want to have a 99-year lease come in to keep the homestead exemption. But the creditor protection is not as good for a qualified personal residence trust, because based on all my research, the creditor could seize the lifetime possessory interest. Now, maybe, so you would do a shorter term CUPERT for somebody with a creditor situation. If you have a Florida client and you're thinking about doing a spousal limited access trust, you should know that the Florida statute says that if I set up a SLAT for the benefit of Marcia, and she has a undeniable vested right in that trust for life to receive health, education, maintenance, and support, and she dies before me, then I can become a beneficiary of that trust, and my creditors can't reach into it. That's a really good thing. So, you have a physician client with a $10 million net worth. He has a spouse who's in terrible health. It's a very sad situation. We'll take a sad song and make it a little bit better. Thank you, Lennon and McCartney. And we'll have him transfer that $10 million creditor exposed asset to the SLAT. It's for her lifetime benefit. Her lifetime's not so long, unfortunately. Now he's the beneficiary of the SLAT. Is that creditor protected SLAT estate tax protected? And I think not, because under Section 2036A of the Internal Revenue Code, if I put an asset in a trust with the intent to benefit myself, they're probably going to come get me. So I think it could still be an issue under Section 2036A. You have to be careful how you do it. And then there's the floating spouse explanation, which could wreck a marriage. Marcia, I'm setting up this SLAT. We're going to get a stepped up basis on the assets when your father passes away. She says, that's good. And it's for your lifetime benefit. I hope you don't kick me out. She smiles and says, that's good. But if you die, would you mind if my next spouse could receive benefits to help me indirectly? No, that's not okay. So that's the SLAT. Somebody once said, I don't want the SLAT used by a slut. So whatever that would be, spousal limited unitrust. All right, there's your Florida Trust Code provision. I know that you really wanted to see the Florida Trust Code. Okay, Matt had a great question. If the LLC is the trustee of a trust, what Florida law applies? The answer is none. Like many states, well, actually, like some states, sorry, I'm playing with the questions here. Like some states, Florida does not require the trustee of a trust that is a company to be a registered licensed trust company. So our documents say that any trust company appointed under this trust agreement must be a licensed trust company if that's what we think the client will want. Otherwise, any person or thing, someday an artificial intelligence entity, will form an LLC on its own and be the trustee of somebody's trust. It'll troll the internet for somebody with a trust who has the right to appoint a corporate trustee. He'll get them to appoint the artificial intelligence entity, and Florida law will not prevent that, just so you know. But when that allows law firms to serve as trustees of trusts in Florida, for example. Okay, so we have a lot of slides because slats were popular. Now, Florida has a community property trust, and that allows a step up on the first death if it works, but creditors of a community property trust can reach that. And if you have clients in a community property state, please tell them, especially California, Texas, if one of you is in an accident, your community property is all exposed to the creditor. So why don't you move to Florida and transmute your property to tenancy by the entireties if that's a big concern? Well, we weren't trying to outrun the creditor. We were just following our children to Florida. And once we got to Florida, we transmuted out of community property because that's what our Florida lawyer told us to do, because he didn't know much about community property. Have the article here on stepped up basis that Jonathan Blottmacher and I wrote in 2013, and you might want to look at that. I'll mention the Jest Trust. I'm not jesting here. You could have a joint trust owned 5% by me, 95% by Marcia, but if I die, I have a power of appointment to creditors of my estate, if approved by my next door neighbor, that funds that trust into a credit shelter trust for Marcia that, in my opinion, if you do it right, gets a step up in income tax basis and can fund the full credit shelter trust. So I strongly recommend that you think about this if you're an advisor, that if Marcia and I have 15 million of assets, and when one of us dies, we want to fund the whole 13,990,000. We don't know who's going to die first. She hopes I do. And then I don't want it all in my name. I don't want 13,990,000 in my name because I might get sued for some reason. Put it in the Jest Trust. I own 5%. Marcia owns 95%. I die with that power of appointment, goes to Credit Shelter Trust, fills up the whole Credit Shelter Trust, gets a stepped up basis. Marcia is protected from her next husband, who will be much nicer than me. And everybody says hooray, but me, because I'm gone. Then you can explain to your clients that a revocable trust does not protect assets from creditors that are in the revocable trust. You want to make sure that you tell them about that. I was very proud of what Howard Zaritsky and Lester Law said about the Jest Trust. With the help of some friends, I came up with the Jest Trust when I was writing an article with Howard in 2012, and he was thinking it couldn't be done, but we did find a way to get it done, and you can read about it yourself in Trust Adventure magazine. It was the February 2013 adventure of Trust, issue of Trust Adventure magazine. Another thing for you planners, no matter what state you're in, including the state of confusion, is have an agreement signed between the spouses, which says, if I die, you will put at least 90% of our net worth into an asset protection trust to protect you from the next spouse and to protect the inheritance of our children. You'll be co-trustee with one of our children or one of our friends or a trust company, and this will protect the assets, because so many Floridians have large tenancy by the entireties assets, and one dies, it goes to the surviving spouse, and then it goes to somebody who was at the funeral, who brought cookies, and it was love at first sight. The widow or widower loved the new person, and the new person loved the assets of the widow or widower. And guess who inherits it? The widow or the new spouse's descendants, of course. Well, not if it's in one of these trusts. And then that's a good business reason to set up an asset protection trust. My spouse died, and I was required by contract to set up an asset protection trust. So it requires just a fairly simple agreement encourage the clients to have separate legal counsel, disclose all assets, and we have found it to be a very important part. You know, you meet with the client and you say, oh, by the way, I finished your estate plan. Do you realize that if one of you dies, the survivor can get remarried and lose it all? What? And you didn't tell us? Well, it just never came to mind. Doesn't everybody know that? So let me see, I've got no minutes left. I'll just tell you there's a lot of other stuff here, but there's other asset protection stuff. There's Marcia driving our airboat, and my daughter Nicole and Nicole's friend, and our Monty Python found our grail, and we also found our buyer, somebody to buy this boat from us after a period of time. So we talked about liability. If you want to save probate on a house, you could do a ladybird deed. You don't need to put the house in a trust if you're worried about Judge Proctor's decision. So ladybird deeds work fine in Florida. And then we do have information for you on asset protection trusts, et cetera, et cetera. So let me see if there's any other questions. Let me see. Could you go slower, from John? And then Mary said, could you go faster? Okay, that's typical. All right, so now I get to show you something on Estate View. The program's over. And let me open up Estate View. Wake up, everyone. We're going to talk about Estate View. So I go to estateview.link. This will take about 3 minutes, maybe 4 minutes. So you go to estateview.link. I'm a subscriber, which is such a cool thing to do. And I go, oh, it talks. Okay. I click on Instant Plan. And then I can go with full intake form or calculator only intake form. If I go with calculator only, then I don't have as many fields to fill in, and it will automatically do a lot of cool stuff. If I do full intake form, or I could customize the intake form, I could go with page by page, click Get Started. There's my intake form, and I can fill out the intake form. Now, down at the bottom, there's an instructional video. I'll turn that off for now. And I'm going to say replace all inputs with sample data here, which is what I've got, my sample inputs. Or I could clear all those inputs at the bottom left, and I could fill this out. Or once it's working perfectly, I can send it to the client. The client can fill it out. We're still in beta here, which has nothing to do with fish. So very quickly, I've got a lot of input here, all sorts of things that I would like to know about a client, but the client does not need to fill out everything. Just whatever the client fills out, that's what we'll deal with. So I've got spouse 1, spouse 2, I've got the children, I've got the relatives. I'm asking, will you inherit from your parents? Will you support your parents? How about your grandchildren? Have you thought about college? Do you have savings? How much are you saving a year until what period of time? How much are you spending a year after a certain period of time? What's your house worth? What's the appreciation? What's your vacation home worth? What's the appreciation? Et cetera, et cetera. Would you consider charity on death? And also, what other charities are you interested in? What's your life insurance? What are your other assets? Who are your advisors? Who are your fiduciaries? This college thing is cool. He's 16 years old. You've saved $60,000. You figure he's going to go to private undergraduate, and then you're hoping he'll go to graduate school. You're hoping for an MBA in state. All right, you need to immediately put aside $218,889.32. And this is what those years are going to look like for you financially. All right, then there's optional questions, and we can add questions that you like or don't like. some of the questions you might have fun with. Would you like to discuss trust and estate litigation risks? If yes, you fill out these questions, and then at the end of the questions, it tells you whether your risk is low, medium, or high, and the questions give the client ideas about what they could do to reduce litigation risk. All right, so you put that information in there, and then I can click Review Summary, and it, of course, tells me all the information, and I can print this out, bring it into the conference room with the client, make sure I've got the right information so I can fix the misspellings and all that stuff first time around. And then I can click on results, because clients want results. So you click on results. It's just run 44,000 calculations approximately. And now here's the 3 things I like best. The thing I like very best, to be quite honest, is when I meet with a client, I like to have a summary of all of the information for the meeting. So I click on Generate Planning Chart, and I choose joint assets with one trust, joint assets with a trust but homestead not under the trust, or joint assets with 2 living trusts. Click on that, and it sets up an Excel document. And that Excel document summarizes all their data on one page. Now we print this on we have a large printer. You could print it on ledger paper or 2 ledger size pieces of paper and put them together. But in the conference room or during the Zoom meeting, I show this on the screen. And then I take notes on each asset. It shows me each asset. I can take notes right into the Excel spreadsheet, or you can use a Google Sheet. And then it also has summarized their assets for them. They really like this. Now, my staff gets fancier. If we have time, we'll put their pictures here. We'll put a picture of their home here. We'll put their children's information here. We put their advisor's information here. But this is what I use. This is what I like best, what the clients like best. But the other thing, I can export to Excel here. And when I export to Excel there, let me see, go there, open it up, intake form. Where did it go? It's got to be somewhere here. Let me try it again. It should have opened. Open. All right. So now this spreadsheet comes up, and I say, here's all your assets by relative size and value. And on your retirement date, when you told me you were going to retire, here's what they're going to be. Your investments will go from 21 million to 40 million if all the information you gave me is correct. And also, here's a personal financial, let me see where that is. Okay, personal, how come it's not doing that? Asset allocation. Well, oh, hit enable editing, maybe that does it. Or something's locked. All right, well, take my word for it. It gives you a personal financial summary and then a column by column thing. I don't know why it's not working. This is embarrassing, but I'm sure there's a reason that my programmer will explain. All right, so then what I like is it gives them a family tree. So when I'm sitting in the conference room with them, I know who's Bob and who's Bobby and who's Rob and who's Robbie and which grandchildren came from which child. And I even know their friggin' family pets because they love to talk about their pets. And then I have a calendar I can give them as a gift. Here's a calendar. It's got all your anniversaries, all your birthdays on there. If it's a bachelor, he probably doesn't have this. He probably would like to have it. And eventually we'll get a reminder system going for them. And what else do I have? Oh, I have a married comprehensive estate tax plan for them. No planning, 10 million of estate tax if you die in a year. If you do the planning and you die in a year, no estate tax, but a lot going to a charitable lead annuity trust. If you do no planning, then through your life expectancy, 100 million estate tax. Bypass trust brings that down by 8 million. Cupert brings that down another 12 million when you count the rent you paid. Annual gifting brings it down to 47 million. Discounted gifting brings it down to 34 million. Life insurance trust brings it down to 35 million. A large gift of 1/3 of the investments into a discount LLC brings it down to 9 million. Rolling grats bring it down to 8 million. And then also an installment sale brings it down to 546,000. This is a smart computer program. Thank you, Kevin. This is perfect. And then a testamentary clat brings it down to $1.8 million. It has all these different calculators. I can also say, hey, I want to talk to you about getting an investment advisor, because you should understand that the rate of return can vary based upon what actually happens. So while we're hoping for a 9% rate of return according to market data, there's a 10% chance you'll only get 6.7% or less. There's a 10% chance you'll get 11.61 or more. And the difference is huge. 27 million versus 113 million. So we need to plan for both of those eventualities, both as to your retirement planning, which we believe you have enough to retire on what you wanted based upon what you told us you wanted as of now, and also your estate tax planning. But then I have something else that I really want to show you, and that is there's some things we should discuss. And according to my software, based upon the questions that you asked, I think we need to talk about why mom signed the learner's permit and he's driving dad's car. Stop that. You need to move that car he's driving to mom's name, because she's going to get nailed under the Florida statute until he's 18. And then once he's 18, give him his own car. And then you've got an inheritance coming from your father, John, and you're going to have to provide financial assistance to Elizabeth. So let me ask you, should John prepare an inheritance, leave assets to an inheritance trust for you? And should Elizabeth talk to a Medicaid lawyer? And would you like to fill out a separate application for Elizabeth to see where you are on the Medicaid world? And you've got pets. You may not have umbrella insurance if your pet is one of these types of pets: Dalmatians, Mastiffs, Great Danes, Pit Bulls. You got a 22-foot boat. You realize that probably doesn't come, it's probably not covered under your umbrella unless you get a new separate boat umbrella. You've got a silencer. You need a gun trust. If anyone is going to use that silencer besides the owner, trustees of a gun trust can use it. And if there's medical marijuana in your house, you're committing a felony. And you've got real estate in your name. Shouldn't that go into LLCs? And you're not sure if you have umbrella insurance, et cetera, et cetera, et cetera. So we would love for you to look at this and let us know what you think is missing. And right now, what we're working on is an automatic letter that would say, here's what you have, here's what the concern is, here's the story about what happened to somebody with the same situation, and here's the advisor that we recommend should think about handling it. And then if they don't have that advisor, we can say we recommend that you find an advisor who handles P&C policies with knowledge of boats to make sure that your boat is covered. So there's a lot more here that we're working on and that we're getting our arms around. It's not working perfectly yet, but I'm pretty proud of it. The other new feature that's coming along nicely, and by the way, everybody who started this program is still on it, so I assume you're asleep or you're paying attention. Oh, by the way, in case this is the first time you've seen it, I'll just show you that you, once you get in here, you click on, once you've got your results, you click on Save to Calculators there. And now it'll automatically put all your data into all these calculators. So, if you have one of those other calculators where every single calculator, you got to fill it in again, and then you got to fill it in again, and then you got to fill it in again, and they can't compare to each other. Here, I just click Save. It's exported to the calculators. All right. Then finally, I will take you to the AI document review. Now, presently, we have two different types of documents that we can review: trust or estate document or buy-sell. And then you copy and drag your document into it. We are SOC 2 certified. The internet does not learn from our documents. If you want to be super safe, you could sterilize it. And you can try a sample document. So we have some sample documents. So I go ahead and click the sample document. Now, what it's doing is it's dividing the document into chunks. It just spent a little bit of time. It divided the document into chunks. And if I ask it a question, for example, I can just ask it a question. What are your drafting recommendations for this trust? And now it's going to spend usually 2 to 4 minutes going through the document, looking for the drafting. Now, if you do this in ChatGPT 4.0, it's going to be a lot faster, and it's going to not be nearly as good because ChatGPT 4.0 knows what ChatGPT 4.0 knows, but does not have protocols or guidelines. So it's less tame. We have about 20 pages of guidelines. So right now the computer is going through the document 1,000 words at a time. It's called chunking. It's looking at 1,000 words at a time. It's on your computer, not mine. Your computer is using the Amazon-based software to do this without it going onto the internet. And that's why it's taking a while. But what it's going to do is it's going to give me instructions. I mean, and there it is. So what I gave it is a perfectly good document that we commonly use. But it's still, as you can see, and you could read this later, I could send it to everybody, it has recommendations that come from our list of recommendations. If you find that there's not a Scrivener Protector provision, recommend a Scrivener Protector provision. If you find that it's arbitration based, warn the person that arbitration can be expensive. If there's no arbitration, talk about the advantages of arbitration. Is there a power of appointment? If there is a power of appointment, is it limited? So now I could say, I can go down here and I can say, please prepare a trust protector action that makes these changes and requires beneficiaries to graduate from college before they can be a trustee or receive anything other than educational expenses. And then, I'm sorry for the typos, but I don't have to fix them because it knows what I want. So there, I click on that. And by the way, I could also ask if the document does not have a table of contents, it will give me the table of contents. So while we're waiting, I'll show you a couple of other features. I can go here and I can adjust the speed detail. So when I adjust the speed detail, I can go fast with not a lot of detail if I'm in a hurry, or I can go slow with a lot of detail. And by the way, we pay a tiny little amount, maybe 23 cents will be paid by us to OpenAI for the work it's doing. Okay, so here's my trust protector action. As trust protectors appointed under 616 of the trust, the undersigned hereby make the following changes. And then there are the changes right there. Now I could say, write a letter to the client and the CPA explaining the changes. So I click on that. Pretty soon we'll have this as a Word document. Right now we just copy and paste it. So, oh, and look at this. After the death of myself and my spouse and the division of trust assets into separate trusts for my children, for some reason I don't know why it is not showing me the whole thing. But anyway, you can see the criteria and what I asked it to do, basically. All right, so right now it's writing that letter. You can see it's writing the letter. Another thing I'll point out to you is that when it originally gave me the changes, I can click here to see where it got the references for that. So this is telling me the exact language of the trust that I should review to see what the changes are. Now, one thing our amazing head programmer Kevin's working on is a red line feature. So I'll be able to say, take this trust, and everywhere where it says grantor, say put settler, and everywhere that it says that if somebody has to be age 25, make it 35. Throw in a trust protector provision and throw in a scrivener protector provision, and thank you. And then on the left-hand side, you'll see the clean document changing. On the right-hand side, you'll see the red line being prepared, and it scrolls as it prepares. So then you give it to a good secretary, and the good secretary has saved a lot of time. She cleans it up. It's going to make mistakes. It's not going to be perfect, but here's the letter to the client and the CPA. It's going to take them both into consideration, and then it's going to say, here's the changes that I've made. All SOC 2 protected. So I think it's crazy not to use this. Now, if I want to just see the document, I want to know what the document looks like, I click on See Document. There's my document. I can click on Hide Document. And then I can click on Clause Generator. And I can just describe any clause I need. And then when I describe the clause I need, it puts the clause into the proper place in the document. And then I can also ask for an executive summary, et cetera, et cetera. So let me go back to home and come back here. And the other thing, just so you know, because you'll probably be wanting to do this, again, I got to drop in a sample document. I have to start over. I was a little clumsy there. It's reading the document again. It does not save the document. You have to save the document on your computer. For confidentiality purposes, the way this works is, and it's really neat, the Amazon cloud system of software has settings, and the settings provide, if you set it properly, and we had, you know, all the expertise do this, if you set it properly, only your computer is seeing this data. But what I can do for an automatic is I can click run. When I click run selected analysis, it does all of these things. It may take 20 minutes, but I'll be doing something else while it's doing it. So now I'm going to get an executive summary, a client-friendly summary, spot issues, tax analysis, compliance checklist, and drafting suggestions. So I can read that in about 20 minutes, and now I know all about that trust. So instead of spending 3 hours reading the trust, I know all about it. Now I know what to look for in the trust. So that's going to increase the standard of practice for careful practitioners. For sloppy practitioners, it's going to do some harm, but it's also just a great checklist, because, you know, when I read a trust, 8 or 9 things I think of, then I have my partner read it. She thinks of 3 or 4 other things, and another, you know, I missed a couple things. Well, we have a pretty good checklist here. So if anyone's interested in helping us grow this as far as develop these things, I've got a lease reader, an employment agreement reader, and a buy-sell reader coming up. So there's the beginning of the executive summary. And you see, it gives you the names, it gives you the section numbers, tells you what's going on, and then it gives you the key language that it derived that from. So just read this stuff is the most important. Read it first. We'll keep developing this. Thank you so much for following me through 24 minutes of Estate View. If you're interested in it, just send me an email. Really appreciate it. Let me see, any other questions? Nope. No other questions, so have a fantastic rest of your day and weekend. We're always looking for suggestions for programs. If any of you would like to present a program for us, you would be more than welcome to do that. Thanks again. Have a great day. Bye.